那么接下来我们就请这个德国智财法院的这个首席法官这个加多里，那他这个法院啊，如果我记得没错的话，应该是在慕尼黑卡尔广场那边。
Thank you very much.
那谢谢他哈，我现在掌声欢迎他。
Okay, good afternoon, ladies and gentlemen, and I try to explain you a little bit about one of the reasons of the present patent war, and one of the reasons is patent density.
那现在说他来解释一下为什么最近有这么多的这个专利诉讼，他来讲一下这些专利密度的一个问题。
And I try to explain how this phenomenon of patent density arises.
那现在会来解释一下这些事情是怎么发生的。
Okay, if you look at the number of patent applications worldwide, then you can see 10 years ago it's a steady increasing number of patent applications, and even there's a steady increasing number of patent grants.
现在是专利的核准跟专利的申請越來越多，也越來越快。
But what are the impacts of this? The impacts are, on the one hand, the application, grant, and enforcement of patents, because you have increasing costs for applicants, because the research is a lot more expensive the more patents exist. There's a lot of costs for the patentees, because the enforcement of your right will be more and more expensive, and there is a lot of work for the courts.
他现在说的，专利申请越来越贵，但是其实量还是很多，对法院、对制裁局都是很大负担。
And on the other hand, you have problems by the conflict prevention, because you have, as I mentioned before, an increasing cost for citing, investigation, and translation of your patent claims.
在欧洲最麻烦一件事就是你要翻译成各国语言，这是非常贵的一个费用。
And but it depends in which sector of industry you are in, because there's no or even a little effort on industries working in a free state of the art, but there's a lot of effort and cost for innovative areas, especially mobile phones and computers and so on.
因为现在越来越多的专利其实都只有一点小小的修改，或很多时候都只在它的新型专利上，但其实并不是很大的创新。
Because there is only a limited number of real inventions, there must be reasons for this patent density, this increasing number of application and granted patents, because the people are not more innovative than 100 years ago. And real inventions are very rare still nowadays.
古时候的发明其实重要的才会去申请，但是现在我们以台湾来讲，好像TSMC 啊、SMC 一年都可以申请几千件，那个品质跟数量其实是非常不一样。
You can only once invent the wheel, and so there is no room for real inventions more than a little percentage.
所以现在真正的发明其实占的比例非常少。
So let me ask you one question: how do these patents arise, or inventions arise, and what is their scope of protection?
那现在问题发生了，那它的保护的范围应该到哪里？
And there you can see the people are very innovative, but not dealing with inventions, but dealing with applications. And we have an extension of the definition of the term invention. So first let me start with the patentability of discoveries, which should be excluded after the patent law worldwide, I guess. But sometimes very clever lawyers, sorry Mr. Lehmann, come to the offices and can gain a victory by being granted with a patent for a discovery. And one example for that is a decision of the enlarged Board of Appeal of the European Patent Office about 24 years ago.
现在给我们一个24年前的案例。
14 years ago.
14年前。
where the so-named second medical use was patented. As you may know, for example, there was a medicine called aspirin, which is 60 or more years old. It was an invention by the company Bayer. And its only substance is salicylic acid. And it was medicine against headaches and so on. And anyone came and found that the same substance, I call it ASS, which is more simpler for me.
Is it aspirin?
Also can prevent some kind of heart diseases caused by thick blood.
Osteoporosis, 就是那个周状动脉硬化。
And he wanted to get granted patent at the European Patent Office, and the European Patent Office decided, as you can read. So even if there is a substance which is well known, then you can get a patent if you find a new feature of this substance.
我简单解释一下，阿司匹林以前是镇痛止症，后来发现可以治疗那个血栓，那所以现在有新的适应症，那欧洲的制裁局觉得它是可以给专利的。
Since then, we have the second medical use. Actually, there's nothing more than an advertisement which is patented.
那现在就说呢，虽然说没有什么新的合成，但是它有新的应用方式，那新的应用其实是可以取得专利的。
Or in the best case, it's a discovery but not an invention.
所以说这个是发现的，不是发明，但是也是可专利的。
But on the other hand, you can find more innovative creations. For example, the patentability of aesthetic creations is excluded by all patent law I know. And here you can see a European patent with the number 1753671, where a container containing only normal laundry detergent tablets was patented with the argument these should be a technical effect to place two tablets beneath each other.
他现在说本来是这个是洗碗机嘛，那现在把那个消毒机清洁剂放进去，这样有这个想法进去，可不可以给他专利？
And so you have a translation of aesthetic effects in a technical effects, which is not real. It's only for this patent. And the consequence of such patents is increasing legal uncertainty, because no one knows what is patentable, what is not patentable, and so on.
所以现在对于专利性、可专利性这件事有很多的讨论。
So the next thing, even the patentability of ideas and rules, such as normal computer programs, normally is excluded. And here you have another example of an European patent which has been granted and which is quite young, as you can see in the number. 2005 years old. Where a laundry package gets with a scale of whiteness, where you can see how good or not good the detergent works.
这个就是我们那个洗衣服的机器，现在就可以放那个蒸验机，它加了一个盒子在里面，这样就可以给专利。
And the only technical substance in this claim is the area of 0.5 up to 4 centimeters. That's the only technical.
就是把这个装蒸验剂或者是装漂白剂的这个东西装进去洗衣机，这样子是不是有技术上的一个进步或者是改进，会不会专利在讨论这个问题？
And how can I get to such claims? Yeah, that's a simple case of aggregation of different parts of the claim which are combined together. But there is no technical content, and the consequence is even a legal uncertainty.
欧洲人在给专利比较严格，他觉得像这样这个新的一个设计，欧洲人是不认为它有一个明确的一个效果出来，法律上也不给它这个保护作为不可专利。
And why do I tell you that? Because that you look, if you're dealing with patents, please look at the classical parts of a patent, which has to be new, which has to be an inventive step, and so on. And if you are dealing with patents, then you have to deal with the term of novelty, and the more restrictive you see the novelty, the more you have the problem that you will get patents close to your first patent.
如果这个新颖性越高，被核准专利的几率才会比较高。
And the more you have patents close to the first patent, the more you have difficulties to prevent selection inventions and so on.
现在就说呢，另外要避免就是有一些选择性的专利，比如说故意抵单的乱设计，把它抵单的乱，其实可能就是要侵人家的权利，这种专利就不让给。
And the consequence is the more you have such selection inventions and patents close to the first patent, the more you have an increasing number of claims and an increasing number of description pages to declare your patent and to limit your patent against the first patent.
现在说，如果你的专利是基于别人上面去做改进，那你就要花更多时间写更多的权利项、更多的说明，才能够被和解，才能为最后被告侵权。
And let me do a little comparison to some countries with a high patent density. First, let me start with the United States of America. We have Americans have a teaching suggesting a motivating method, which is, in my opinion, better than the problem solution approach of the European Patent Office.
在美国，他们有一些方法原则来判定到底有没有侵权。就刚刚讲的这个他有没有去暗示你，有没有去引起这个动机？但他觉得应该是怎么样去解决问题，怎么样去解决这个方法的这个动机，才是拿来判断到有没有侵权。
And especially that's very important, in my opinion. There is a strong obligation to cooperate for the inventor or the applicant or the lawyer with the patent office, and that's very important.
虽然说在申请专利的时候，其实申请人啊、律师还有这个还有因为申请人有时候是公司啊，就是说其实他们在申请的时候之前应该要好好的讨论合作，把它申请的时候申请好一点，才不会后面很多的麻烦。
And if you limit your claim in the United States, then the limitation will be forever, and not if you're dealing with for example, with the European Patent Office, some limitations can be corrected later, and that's not a reason for legal certainty.
现在就说他讲的是呢，比如说拒反言，还有那个就是 estoppel 这个问题，就是如果你去修改你的 claim，那你以后没有正式的理由，你是不能回复你的权利。那在这个修改，只要修改了，以后诉讼权是会被拿出来讨论的。
Chapman has the Chapman patent law requires a lot of clarity compared to the European or the US law, and secondly, the Japanese law has a restrictive treatment of product by process claims, but I don't want to speak more about the area of Chief Judge Imura, who knows it a lot better than me, and I will stop here with Japanese.
OK， 他说因为这边有日本专家在这里，但是他们欧洲人的感觉啊，其实日本对于专利的这个揭露是要求很严格的，然后而且对于一些只是制成方面的专利的权利项目，其实是有很高的一个限制。
And then let me, last but not least, go to China, because it's very simple for me, because the Chinese patent law is very similar to the German patent law. There is long-lasting and very intensive cooperation between the SIGO and the German Patent and Trademark Office, and so the law is very similar. But the only difference to the German law is the definition of disclosure, because there is a little bit more in China than in Germany, and there is another difference regarding the definition of novelty, because China has a very strict definition of novelty.
我必须讲一下，就是说，其实现在呢，中国的智慧产局跟德国的制裁局是直接相同的，所以这是为什么请这个欧洲专家来，希望台湾要很清楚。那 那我很快解释这个部分，就是说他讲的这个揭露跟新在，因为我们开发跟国家为了要保护我们自己的地方产业啊，其实像之前刚刚讲的那个伟哥的那个案件啊，他之前是有分子的时候没有公民，他是不给你专利的，所以他说你要有一些真正的创新新颖，那不是只有你揭露他就给你专利，在这比较严格，所以那个时候这些修法上面有一些每个国家都在协商怎么样同意。
For example, the German jurisdiction says novelty is all things an expert on this area knows. It's not only this what is written in the patent, it's also what he reads by his expertise.
他现在说，在欧洲人的认为啊，你的新颖性必须是非常的专家认为新颖，不能找个路人讲，路人你觉得他很新，他们是要求比较高的。
So it's quite a lot. And then, thank you for your attention, and I hope I copied the right signs here.
Presiding Judge Voit。那关于这个部分呢，就是说我想补充一下，就是关于这个专利审查密度的这个部分啊，我记得好几年前我曾经承办过一件关于电风扇的这个侵权，就是侵害专利的案件。那关于这个电风扇的底座是圆的，是方的，然后它的组装的方式起结，这都提到那个法院来。那事实上，法官对这个部分啊，说真的，如果都没有专家的协助的话，是很难去判断那个，就是说那个专利权的有无啊，这是第一个。然后刚刚那个Voit有讲到说那个就是洗碗机啊或洗衣机，那因为我们家是这个Voit洗衣机和洗碗机的爱用者，所以我这边先说明一下就是说关于这洗碗机啊它不但有自己专用的那个粉。它还有洗碗机的芳香剂，还有洗碗机的那个洗涤剂。所以刚刚那个站姐他刚刚讲到说，这个洗碗机的这个部分这个算不算是一个那个专利？会不会取得专利？这个是真的是蛮可以讨论的，这是我们很难想象的。然后关于那个洗衣机那个过去洗衣机有。就是说，它有3个船型盒，有3个盒子。那一个是放洗碗剂的，洗衣剂的，然后还有一个是放那个漂白剂的，一个放那个蒸炼剂的。那这个部分的话，就是说，如果说你有另外一个发明是加入另外一种剂的时候，是不是可以取得这个专利？这是刚刚那个Presiding Judge Voit